has piqued your curiosity, because we'll now have a panel discussion that will actually talk about the nuances of notice and consent and how that entire landscape changes with the enactment of the Digital Personal Data Protection Act. So I'm sure this will set the context for how things are going to change moving forward, and how hopefully maybe this tool will be useful, but we'll talk more about that later. I'm very excited to announce our esteemed set of panelists for the next panel discussion. We have Mr. Ashok Hariharan, who is the CEO of IDEFI. We have Mr. Vikas Chaurasia, who will be joining us from METI. He's Scientist D at METI. We have Ms. Cheryl Pal, who's the Senior Counsel Privacy and Data Protection at MasterCard. And we have Mr. Supratim Chakrabarti, who's the partner at Khaitan and Company. I invite all our panelists to join us on stage. Thank you so much to all our panelists for joining us. I think I've already set the context a little bit about what we're going to discuss in this session. But I think quick opening remarks maybe from all of you about what your reading is of the consent-centric nature of the law, and what stands out for you in terms of how will the provisions on notice and consent, how will they change things as compared to the current practices that the industry is following, right? What do you think will be a fundamental change that we'll see both for businesses and for consumers as well? So yeah, Ashok, maybe you can start and we can go down the route.
The bottom.
So for me, I think one of the most important parts of that of the act, obviously it's about the right kind of notice for the right kind of purpose, but the more important one where I think a lot of leakage happens of customer data is actually around processor management, right? So my critical piece is how do you manage a processor and make sure that they are not leaking data, right? I think that's where, because the fiduciary is now responsible, they will make sure, unlike GDPR world where the processor can get fined directly, so the fiduciary says, hey, it's not my problem. Here, putting the onus on the fiduciary, I think, was a brilliant sort of way that act got sort of the way the act came out is that everybody is now responsible for protection of customer data, especially as a victim of consent gone wrong as myself, right?
I think that's a great point, especially about the victimization, right, of people. And I think that's a fundamental, it's a paradigm shift from where we were with the SPDI rules and where we will now be headed with the DPDP Act, right? Gone are the days where we have a one-size-fits-all, one privacy notice that you can just sort of, pretty much quote-unquote copy-paste across the board for everyone. Gone are the days where we can simply rely on, pre-checked tick boxes. A personal sort of, pet peeve of mine, right? Being privacy professionals for as long as we have. So some of these less than ideal privacy practices we have no choice but to do away with them and move towards better governance in terms of privacy, in terms of how you deal with personal data. So to me, I think it's an absolute paradigm shift from where we were to where we'll now be headed.
Yeah, so I completely agree because it will be a quantum leap for a country like India. But I'll add this with a story, and this is from the time when we went across the country when the consultations were happening for the law. We realized that consent is a very weak ground for processing data, actually. Large illiterate population in the country, people are speaking varied languages. Even the most educated people are not reading what they are agreeing or accepting to, okay? Everyone is kind of pressing, I agree, I accept, and moving ahead, right? So several thoughts were put on the table what to do. One was, do we do ranking or rating, just like our financial instruments? A++ would be great institution, please trust your data and you can freely give, no problem. All of that I think got scrapped, and then finally this consent manager is something that struck a chord. We'll talk more about it, But that's, I think, also something that we should be sort of chatting about today. There are some elements in the consent as that's been mentioned. I think we should also deep dive as we are discussing, because those elements are today not etched out as specifically in the law. And if it is dissected by the judicial bodies and Supreme Court and all that, you could see a lot of new jurisprudence coming, which today we have not experienced. So I'll pause there.
I came into the room and I got to know that a lot of shift in business also is happening. So some engineers are challenging lawyers' earning and they are trying to take their share from it. And lawyers are then further refining their conversation and saying that, say, it's not so simple. A lot of jurisprudence will come over it. so it's a constant happy battle, I would say. But to us from government, we see a lot of innovation coming in this. Because being in the process of this bill and coming into an act for 7-8 years, I have devoted, I can say, 1/5 of my life to this. And that's where I find that when we see in government, we see a very big spectrum of people who get affected by anything which we do. So the similar fashion, this act, when as it rightly said, that the consent to somebody in a village would mean something entirely different, and to somebody who's very well educated, well placed, may mean different and may interpret differently. So we see that a lot of innovation like this, like you have done one level of innovation where you are trying to read the policy of the institution and trying to build a consent notice and around it. But I see that even the core consent piece, consent artifact itself will evolve in so many ways that the kind of pictorial consents would come. Now we know many things, there are standard signs, so that exit sign is so very well in our brain that even in subconscious mind, if there is a fire in this room, everyone would probably recognize the exit sign and move forward and move out of this room. So that fashion, a lot of things will standardize in terms of pictorial and all. And as the whole ecosystem evolves, even we are waiting, being in the core process. So before coming to any event, I give a disclaimer that let's not talk about one specific thing that starts with R. Right, so, but a lot of innovation will come, and I'm very happy that you did a product around it and you are challenging some wealthy lawyers.
But I think before you move on, I think we should talk about the hard work put by Vikas ji. You should talk about your 20 kilometers walk on the day.
Not every event.
No, but this is something, I don't know how many were there in that chat.
I walked for my health. Oh, why should I?
So the day the legislation was passed, he had walked around the parliament about 20 kilometers.
Wow. I don't know whether to boast about it or not, because it also tells that the processes are so complicated. For one paper, they'll say, this, sir, iska Hindi nahi aaya. फिर देन आई विल रन समवेयर, इसका हिंदी लॉ, फिर मिनिस्टर का साइन चाहिए, इस पे इसका सेक्रेटरी जनरल का साइन चाहिए. सो इट्स अ लॉन्ग प्रोसेस. सो I also find it that it shows that it's very complicated. So let it better be buried inside the government and not come out.
Thank you for that fun little anecdote. But going back to something, Cheryl, that you mentioned, and Vikas sir, you mentioned as well, you talked about innovation, and Cheryl, you talked about how, the days of one size fits all are long gone. So I have a follow-up question for you, Vikas sir. I think, what do you think in terms of innovation, what do you think businesses will need to do when we're talking about obtaining unconditional and informed user consent? And specifically, I think if we're relying so much on consent, then how are we dealing with the issue of consent fatigue, right? What is your thinking around that? So, yeah.
To me, because again, from the large spectrum, in this sense, it is not the spectrum of the audience, the citizen, but both the businesses and the citizens. So when you see from both lenses, businesses try to maximize with their consent in terms of their monetization possibility. So they want to maximize the consent or broaden the scope of the consent in order to cater to the main core business purpose. Whereas when it comes to citizen, it is more about the rights and the awareness and getting things not like better in their control. So finding a balance there will be challenging, and I think that will be again an evolving cycle When initially, again, I won't believe, I won't find it like a miracle thing happening that the rule comes and say suppose a date comes and on that date everybody will try to do something best in the world, because anything with a good intent also, there's a business purpose around it which ruins the things. So that's where the awareness with the citizen would probably try to curtail their powers in terms of doing a very broad consent. So that balancing thing will take its own time and its own maturity cycle would be there, but that will be quick because at least in sectors we would see some sort of uniformity. So a bank would do one consent, when it is challenged, the other bank would probably improvise his consent structure, its consent structure. So that kind of sector-wise growth into some standardizations would come. That's my perception.
Yeah, thank you so much. That makes a lot of sense, and I think this is a good lead up to a question I have for you, Supratim, which is, you mentioned in your opening remarks, right, the different criteria that's there for consent, and despite somehow being granular, it's also not specific. It's granular and not specific at the same time. But there's all these adjectives of free consent, informed consent, unambiguous, based on a clear affirmative action. So how do you see this practically playing out? I mean, I'm sure you have clients in different industries, right? What has your reading been on how this?
I think you should reframe again. Yeah. You said how this will pay.
This will.
So suddenly, his mind will be in
some
other direction.
Freudian slip.
Okay, so I think if you look at it, very interesting, very good question. And if you look at the words that are used, some are actually very objective words, like clear affirmative action. There should be a tick, you should click something. And then there are vague terms, right, which you can interpret. Of course, the problem with the entire law also could be that, positive things written vaguely is great. I can decide what I have to do. Negative things written vaguely can be problematic. Okay. So, but coming back, so if you see there are certain words which are like black and white. I know what to do. And if I am caught, I can tell you that, listen, there was someone had to tick a box or click and all of that. But there are certain others where you have to take a judgment call, right? Like there, I think demonstrating compliance comes as a very important factor, that you should, as a prudent human being, be able to understand, okay, I'm writing it this way, it would be clear to someone. Now there are problems also, like the friction areas that we talked about. For example, it should be unconditional. Now if you interpret that, this could mean that every element has to be granularly called out and someone has to tick one after the other. In a business scenario, this could be disastrous. You'd be having huge drop rates, right? People, the moment you have more than one tick, people would be disinterested and maybe would not go ahead. But I think there are innovative solutions. Like Sir was also saying, I think I was recently doing a particular matter in relation to a telehealth application, okay? And they said that, for teleconsultation, there are specific rules that are there where you have to take more granular consent. So someone had bundled up everything and made a huge notice and consent, and everything was right at the time when you were getting into the app, you had to consent also. My question to them was, every person who's coming onto your app, everyone is going into a telehealth consultation with a doctor? The answer was no. Can I put it just in time, just the point that Sir was making, can I have a just in time kind of mechanism where it pops up at the right time with all the meaningful aspects that you want to build in and says turn right, don't turn left, right? So you can stagger it. It's how, but the design thinking now needs to start coming in, and you need to be a little innovative about it.
I think both you and Vikas sir sort of hinted at the same things throughout, is the competing objectives is one thing between what businesses want versus what is good for customers, what is required for compliance. So I'll come to you, Cheryl, because you're working on privacy in a very specific area of finance, fintech, and Ashok, you're innovating in this space. So to both of you, I want to ask, what does it take to design digital products and services in a way that it's centered around meaningful consent, one? And how do you balance these sort of cross-functional interests that are there, right? For different, like your product team might want something else, but your privacy or your compliance team will want something else. So how do you navigate that?
Okay, so I'll address your second question first, right, about cross cross-competing interests, especially in an organization. And I will never get sick of saying this. I've said it at every panel I've spoken on. Privacy is not just a legal and a security problem. This has to come from the top. It has to be across the board, across all your departments. If you do not have buy-in from your management to spend the time, the resources, the money on privacy, on ensuring compliance, you are probably setting yourself up for failure, right? So as much as a lot of people, and I've heard this especially from product development teams, right? Yeah, product bana lete hain. We'll make our product and then we'll take it to legal. We'll tell them to figure out what they need to do. At the most, we'll need one checkbox and we'll need a hyperlink and we'll be done with it, right? That's clearly not how we should be approaching privacy at all. And that tone needs to come from the top, right? Now, coming to what your first question and how to actually think about getting meaningful consent, right? Goes back to, again, a very basic principle that you've, I'm sure, heard a million times, privacy by design. You need to start from day one when you're thinking about your product, when you're ideating, when you're creating the product. That's when you need to start thinking about how are you going to collect consent? What is the data that you're collecting and why are you collecting it, right? Once you start building privacy into the product sort of development life cycle, it becomes easier. It becomes easier to think of it not so much as a here's my product, what do I need to make it, what do I need to do to make it compliant? Instead, you think of it as a product that you are creating for a consumer. You have your consumer interests at heart and you need to do business. So this needs to happen at every single step of that product development.
Yeah, I have like 2 comments. Right? One around at least we talk to a lot of our customers, and when we are talking about privacy, a lot of times the business stakeholder is against any of this, right? He doesn't want friction at all, and in fact he wants to use the data for all purposes, every purpose, for children's data and miscellaneous. Actually, if you go to a lot of the banks and just see their privacy policy, you will notice a term a lot of them have today in their privacy policies, which says, I can use your data for any purpose, for any amount of time, even dead people's data they are using, right? So at a very basic level, the consideration that data is the new oil, I think this was the term that people used, I think, about 5-6 years ago, it became a very big thing. Data is a new oil, data is a new oil, and it became the fact that let me store as much as possible for all purposes, and we'll figure out when to use it, right? That reality is gone, right? And or it should go. I think that still happens, but it should technically go. But for that, like she said, you have to empower the digital, the digital officer in the org. The CISO has to be empowered. It cannot be a last-minute thought coming in. And I come from a product world, so as a product manager, I love just putting one tick mark. It is the best thing that can happen to my life because drop-offs don't happen. The bosses love it. Oh yeah, like we onboarded 50 million customers this year. How did you onboard them? Doesn't matter, right? Like that's sort of the reality we come from. So if we are thinking about this, the way to think about, I think consent also is like looking at it as a happy friction. Don't think of it as friction, but is there ways to make it a slightly better? Like, it is the right thing to do to take consent in the right way, but there has to be a way to manage this in a way which is bite-sized consent. Can take it for the purpose that you require it for. Don't have to do that big notice upfront, and some of it you can take calls on. But I want to ask a question which kind of will give you a little bit more flavor. How many of you use ZoomInfo or Lucia? Do you guys know ZoomInfo and Lucia? Which is how you get your people's data. You send emails very easily to people who didn't give you consent for that data. Now the question really is, how did Lucia get that data? Do they have consent from me to have my phone number and email addresses? And then we are using it, then technically you become a fiduciary because you have his data without his permission. Now where will you go get his permission because you already are sending emails? The question really is, how much of our business models today are going to be fundamentally disrupted or changed and in a right way to kind of cover this. I don't know the answer to that, and maybe the three of you can think about it, but I was thinking, I get emails like, I'm bombarded. I get about 100 mails, none of it I'm responding to. In fact, I send it to trash all the time. These are people who are getting my data without my permission, but I'll leave it there. Maybe.
No, I think the change has to be systemic. I think when this law was also getting drafted, someone told in the consultation that all these spam calls that we are getting, will it stop forever? The question is that this is not a magic pill. This is a data law. A lot of people are confusing this with a lot of other laws which are there. For example, children watching anything on social media, right? So this law is a data law, also talking about children's data. We have to be, sort of clear about that. So from a business structure perspective or further models, I think it will be a trickle-down effect, like you mentioned, from the controller to the processor. We have seen a lot of data fiduciaries, controllers, are actually doing better due diligence of their processors to have trusted partners. Not like, 4 people sitting in the room and doing your payroll, you had zero clue about their, processing that they're doing, or, the coverage, the cyber coverage that they have and things like those. But now those things are getting opened up. So I think it will be a gradual process for a country like India.
Be a health consciousness drive. So if data is new oil and people are now getting over oils, so now everyone wants to stay away from the oil in their food. So they should think the same in the organization. And probably there will be a crude way I could suggest DSCI that next meeting you do a session like this where everyone 5 different religions can pray in their own way. That a regulator comes and wakes all your top management by a fine, and all your problems will be solved then. So it depends on the regulator coming in and bringing that structure in this whole regulatory space. But slowly it will happen. I'm very sure that because we were coming and then we were discussing, while coming here we were discussing Maruti has done a lot in their cars. So that was, a point came up that it was a healthy competition which made them innovate. So that will come in any sector, I would feel, and that will come here also, because you could not be a processor, you could not gain business from a company which is a large fiduciary unless you are a happy processor. When you are a compliant processor, then only you get business. So it's that sort of branding and image issue, I guess.
Supratim, you and both Vikas sir, you talked about governance and due diligence and what will need to happen there. But do you also think, we've talked a little bit throughout the last 30 minutes, but do you also think technological interventions for meaningful consent will sort of aggravate over the next couple of months as we see the law being enacted and enforced? And specifically to you, Vikas sir, I think everyone here in the room wants to know a little bit more about consent managers and the thinking beyond that as a technological intervention for meaningful consent. So over to you.
Not exactly as meaty, but in an individual capacity, I feel that consent manager is still very, very far away, because it involves a cost, and as the mandate for business on consent manager to be data blind kind of forces the consent manager not to think of this as business, because there's no potential of earning around it, because you have been asked to be very, very strictly behaved, and you are under a very close regulatory regime. And if you see DPDP, the only regulatory powers are with respect to the consent manager, and whereas all other are kind of only problem solving and complaint resolving mechanisms. So in that capacity, consent manager turning out as a business is challenging. And if the customer has to pay for it, it will take a long time. You all know in the businesses, even you're struggling with making the fellow do 10 ticks. And if you say pay 10 rupees, then definitely you're losing that customer. So who will take that cost? All that has to evolve. So that will definitely take time. First, I personally feel that first companies will come to some level of consent manager, and this is a luxury service which will come when the basic things are done. I feel so, but not as meaty as individual. Because it is an enablement. As we know, it's a very tedious process getting a law passed. So we thought that there is a scope, there is possibly an appetite. Sometimes the things click very fast. We don't know how fast it will come, but still ahead, but having that in the law enables us to do something around it later. That's our thinking.
Right. So I think to the first part of your question, I think the problem created by technology can also be solved by technology. So in all this digital space that we're looking, right now in, I think some bit of digital help or tech help will actually prod us to move in the right direction, right? Your Truecallers of the world, is kind of nudging you that, this is a spam call. You may decide to take or not to take it. So I think we will be definitely moving towards that zone where technology will aid more of our decision, which is for the good. Coming to the other part of the question, which is on consent manager, we have a very good avenue which has been created. Now, like Vikasa was saying, there are some shackles which are also there. Like, why should someone do this? There has to be a business case. And let's see, how this evolves, but there could be some very innovative solutions depending on how regulators, authorities look at it. For example, on an aggregated, anonymized basis, if on a sector-specific basis, if that data is usable by that consent, then it will make business sense. Because you are right, sir, that I don't think individuals will pay. It may be a very elitist concept in a country like India that I'm paying for my consent manager. But if that consent manager within the guardrails that have been provided are able to utilize that data set, maybe for pharma sector, for retail sector, on a completely aggregated, anonymized basis, probably we could see some takers and it will be having some offtake.
Got it. I think I'll maybe close with a question to both you, Ashok, and Cheryl, and then we'll open it up to the audience for Q&A. You both talked about innovations, Vikas sir and Supratim, you talked about innovations around consent, right? But across the board, if we want to improve privacy maturity in India, right, what innovations need to happen on that front, specifically again for informed and specific user consent. I feel like I'm constantly repeating my words here, but what kind of innovations are maybe happening at your company, if you have examples to share on that front, and otherwise what do you think needs to happen to improve privacy maturity in this space?
Okay, so the way I think about it is that there are actually two parts to this question. One is general privacy maturity, which, if we're all being truly honest, is probably concentrated in this conference right now, in terms of people who are aware, people who know what needs to be done or have some idea of where we're headed, right? We're still a long way off before we reach, generally as a country, as different industries, different businesses in India, we're still a long way off, from being privacy mature. That being said, privacy is never a, an end goal or an end destination. It will always be a journey. We will always keep evolving. We will always keep moving in that direction, right? So I think, and I may be repeating myself here, but again, right, it is for organizations, for industries, including, organizations like DSCI and other trade bodies, to do more of these events, to actually create that awareness of not just what is in the law, but conceptually, what are we doing for privacy governance, right? That really needs to be ramped up. And I think with that little push of the DPDP being enforced, and compliance becoming a legal requirement, people will start paying a little more attention to it than they have in the past. Right now, in terms of innovation itself, and I think the fact that we need to get quote unquote informed consent is going to lead to innovation. Specificity of purposes that you're mentioning in your notice and the consent you're collecting in relation to that also is going to lead to creative solutions. For example, where, and I think Supratim, you had mentioned it, a lot of our country is illiterate. Even if you give them a translated privacy notice, how much of that will they be able to read and actually process and understand? So maybe we'll move in the direction of having perhaps videos, right, which explain what you're doing with this data, what is the data that you're collecting. As MasterCard, we know that there have been instances where we've done something similar. Of course, not in India, but for certain projects that we'd undertaken in Africa, where we didn't have the ability. I mean, we of course had our notice, but we also had videos explaining what you're doing, right? So I think that it's happening. People are getting more and more creative. Our privacy generator, I mean, notice generator is again a perfect example of it, right? Which will help smaller businesses really come together and try and figure out how to collect consent effectively and in the appropriate manner.
One funny thing that I was just thinking about it, right? How much are you willing to, how much money would it take for you to get rid of, like, give your data to anyone, right? Like, and that question kind of hits me. If you think about it, there are people like, probably in this room will say, hey, at any cost, I'm not sharing my data. There are people in India at the grassroots who will probably sell it for 5 rupees, right? And that's where the world is. Like, India is in that big spectrum, which is probably a small group which is very particular about it because we get bombarded. We are the customer base that everybody chases after, and therefore we care. The people now, there are going to be about 400 million people who will enter formal economy over the next 5 years. They've probably already given up their data to a large extent, and then at some point they're going to say, oh my God, I don't want this data to be publicly available, and they want to revoke. Now the concern is you have already given. So now revocation, how do you deal with it? So I think there's going to be an interesting play over the next 5-6 years where what you have given consent for, you want to start taking it back, and what then do you do with the data? What do you do with the way you have structured your organization, the way you have used the data in the past, and all of that will come into fray. Second is, there's AI in the world, and AI can be used for good. And Vikasa was talking about how you can depict consent through pictures. Why? That's very easy to generate using AI models, right? And computer vision models already exist for you to do that. And obviously we use our own LLM for doing the translation in the privacy notice. And one of the things, like for example, I'll just give a very small example, but it'll give you a sense of the kind of depth you can go into. So PAN verification can be translated to Tawa verification if you had sent it to Google Translate. But to say that it's still PAN requires a little bit of knowledge of the regulations. It requires knowledge of RBI regulations, SEBI regulations, as well as the DPDP Act. So being able to, and you can use technology to do all of this. It's actually quite powerful, and that's kind of what we have done. But imagine the next step is depicting through images. Next step is, what do you do for accessibility? What happens to a blind person who has to give consent? What about if he has a nomination? There's a person who's challenged, or differently abled. Now, there's a very interesting one, because even if we work in the KYC space, if somebody is differently abled, he still has to go to the office of the bank to change his KYC. He cannot do it from home. Video KYC does not allow for digital KYC of people who have nominated someone. And that's so horrible if you think about it. So there's actually a case going on in the High Court in Delhi as we speak, on trying to say, how do we treat people with disabilities? And I think this can go endlessly, but really it's about inclusion rather than exclusion. And I think that's the way we should be thinking about privacy.
One final realignment thing that I have seen, I think maybe 200 drafts of the act and bill and everything. So we've seen possibly all permutation combinations of how a word could be placed, but privacy, if we try to achieve it, is too much, because that's where we stick to definition-wise data protection, which has limited set of understandable, comprehensible kind of scope. So that's where I always feel everyone talks of privacy. Privacy is something which, when we were discussing this and trying to come up to some solution, then we thought that privacy is something which is really what it means to you may not means to me. And that's where there is no end to it, and there's no jurisprudence. Even what privacy means to one court will definitely not stand scrutiny of the other court. So that's where we should try to be in the realm and be there in data protection and try to achieve, and then slowly we'll do that. Thank you.
Thank you so much for that. So we have about 15 odd minutes for Q&A. I'm sure this was a really nice panel, so I'm sure there's some questions in the audience. Can we get a mic at the back, please?
Hello, thank you for all enlightening discussions in this panel. I have a question pertaining towards the privacy policy management. I just want your views on the need and the current state of a accountable grievance redressal system or mechanism that should be in place, because I'm sure whoever are there, all the members here in this room must have faced some or the other day, you want to use a service or an application, you are in really need to use that service, and you get a privacy notice and says same, all your data for any other purpose, and then you have no option but to click accept, and then you go on use the service. That's one part. Second part, you don't want to use the service anymore and you want to delete that application, or you want to get logged off from the service. Very few applications have the option to allow user to delete, give some option to delete their data where they're no more using the service. I hope this is the same situation everybody would have addressed, and what's the current state and what are the needs to make it better when it comes to managing privacy.
Okay, can I get started? So basically, this law does provide about the right of withdrawal, and actually it has to be as easy as giving of consent. Under GDPR and other similar legislations, we have seen some disputes also. There have been good decisions on this. You cannot have I agree right at top, very easy to find out, and I want to withdraw hidden somewhere, or to be on a call with a call center for an hour. So that will not work. So that withdrawal has to be as easy as giving of the consent. The first part of your question was that about I think consent management, right? Grievance. Okay. Yeah. Sorry. So grievance. See, again, I think I'll go back to demonstrating compliance as the parameter which has been set out. Already, if you read some of our new digital laws, intermediary related rules that are there, etc., these are talking about robust grievance redressal process, which you have to, and it works both ways. The individual also cannot jump the gun and straight away go to the Data Protection Board of India to complain. They have to pass the hoop of that particular organization, and therefore I would say it's a little balanced. Organization needs to have a robust grievance redressal process where they will be able to justify, because the person after making a complaint may not be happy with the answer given, right? So you should be having that properly documented, that what was the question raised, how did we respond, is this satisfactory in nature? If it has still not been satisfactory, then of course the individual can go up to the Data Protection Board, then to TDSAT, then to Supreme Court.
Yeah, just to add to what Shupati has mentioned, right? This is where, to a great extent, some innovation is also possible. Because for something like a data access right? And if you're a company which has large volumes of data, you have to think of how you're going to automate some of these processes, right? Because if you don't do that, then you're not effectively going to actually address any of the concerns that your customers may be raising, right? So I just wanted to put that out there as well. This is another area which is ripe for innovation. How are you going to manage data subject rights and responding to sort of the exercise of data subject rights?
I have a specific thing to say. If you are a large data owner, you are a significant fellow, and then you have to mandatorily bring one person there. So that's there, and kind of grievance is something which is vital, and you may probably appreciate that when you have a grievance as an user to an app, you are just one instance, and but with the kind of gig economy coming up, you see that movie of Kapil Sharma that is called Ziguato something. So that company, that movie again shows that, see, somebody's whole job, whole life is dependent on an app which is suddenly like, okay, barred. So if you are a delivery partner and you're not allowed, then you have nobody to go and complain to. So that kind of places where your economy, some businesses are today, they don't have a website. They say mandatorily come on an app. So that kind of scenario, grievance is something which is foundation as the consent, and that's where we have already at every point says that whatever notice, whatever consent you are taking, there should be a clear mention of a grievance redressal mechanism, and it grades with normal data fiduciary to significant data fiduciary as per the responsibility in terms. But there should be something, because think of people whose lives are entirely on app-based business, and then they are suddenly nowhere. So they need some person, and at that I would say automation probably would not really suffice, because here the regulatory target is to bring people in. So if you have 1,000 grievance, you cannot automate it to a chatbot. You have to have more manpower to resolve grievance. Rest all business go automate is understood, but here some human intervention to, like, not some, it should be wholly a human intervention driven thing. So an automated process can probably bucket you problems coming in, give some ticketization, all that can happen, but it has to be done in a human way. That's where, so everything else, technology is needed, innovation is needed. Let this be in the crude, simple way and help people. That's the idea.
Yeah. I think it is very difficult to do this if you do not have proper systems in your org. Right, and this cannot be something that goes into a fresh desk instance as a ticket in there. It really requires, like for example, if you look at data principal rights management, right, and he has four rights, right? He has right to review. So you need to be able to show that the data, where is the data sitting, what did you use it for, which processors did you send it to. So this is it's like, so honestly, if you're not tracking it, how will you show it? This cannot happen on the day of redressal, right? It is a practice that you run. It is not a one-off activity. Second, he says delete. Now delete, you have to go find out all the places that you have this data sitting at. Some of it might be in Excel files, for all you know. It might be with people who shouldn't have access to it, and it might be in somebody's email. Now, like, I'll give you an example. You get an email for a job applicant. You send that to a friend on email, you forward it. Now, it is not in your ATS system at all. It has come via email. Now, when the guy says delete, you delete it in the ATS system, but the those two email addresses where people have now forwarded, what do you do with it? How do you know that it exists in this, in all those artifacts that you have across all these systems that you might have covered? And this is where your DLP, for example, needs to connect with your MDM, which then needs to connect to your governance platform, which, by the way, we have. So, and this is sort of the way that you would have to kind of design your systems, right? It is not going to happen as just a ticket coming in and somebody is, answering this. It's literally about people, process, technology. All of those pieces need to come together.
I want to correct myself. Innovation can come at user rights, but when user right, okay, I said find out my data, you did automated only, it can happen, but when I contest it,
correct,
it should be human intervention. That's what I meant to say. Tiered approach, yeah, that's true.
Yeah, hi, I'm Amar, working for Schneider. Thanks for this very nice session, because quite a few things already got clarified, thanks to Sukrit, Vikas and all other panelists. Because primary thing was with respect to consent and how many times we should connect it. Second was with respect to consent manager. But the one point which is still not very clear is with respect to data residency. Today there are some laws in India which are very clear with respect to your financial information that a copy has to be here, and current DPDPA says it can be shared with, personal data can be shared with friendly countries, whitelist countries.
Can I get started? Yeah. So basically, this debate we have had for quite some time, right from the first version. I think we started off with a position of almost data localization, and then we watered it down over time. And I'll tell you what now we have as the law, but before that we should understand why do we have data localization, right? It's basically my country's data should reside in my country. There are several theories and counter theories. One of the theories is a trade theory. my data is my oil, and therefore I should use it the way I want, and that's why it should reside in my country. Other one is a security theory. That is, the data should remain safe. I should have access, or my law enforcement authority, when they want access to it, they should have access to it. And there is a reason, because we have had situations where the government, for say very, very drastic reasons, say terrorism related requirement, also reaching out to some of the players, and they saying that it is in some other jurisdiction, please come through MLAT, Mutual Legal Assistance Treaty. Sometimes it's an 8 to 11 month process. By the time the data rightfully comes to you, it is useless. So of course we had this concern in mind that we need to localize some data, etc. The balancing act that has been done right now, this law states that okay, data can freely go out to any jurisdiction, no problem. But there are two catches. One is, we will come out with a negative list of jurisdictions. Transacting data for those jurisdictions could be restricted. And we know our countries of concern, probably they will feature in there. The second end is that if there is a stricter law, then that will prevail over this general leeway. Simple example, like you correctly said, is payment systems related data can never leave the country, right? RBI's diktat is there. So that will still prevail over this general leeway. So if you look at this, therefore, it's a very delicate balancing act. I'm otherwise allowing all kind of personal data to freely go out, no problem. But there will be these two zones where there will be restrictions.
Yeah, please.
So there is, this law does not segregate this into PI and sensitive person data. This law.
Any kind of data, be it my sensitive, like my medical health information, my financial, even that can go.
Yeah, anything.
Any data.
This is happy world. This is a happy world.
No, I find it very good because some of the, I think otherwise the offtake of this law would have taken much longer time if you sit down and now sort of dissect and PISP. The other problem which I often teach in colleges, I give these chit papers to kids and say that write down what is sensitive personal data. Every person has a different perception of sensitive personal data. So what are we? Is it okay to prescribe by law that this is only sensitive, rest is not?
You taught students, they became assistant professors. How long you want further?
I am Kumar from Narayana Health. So in hospitals, we have, let's say the patient is in the operating table, right? We do for a lung operation, they find some complication, they have to deviate, they have to fork out for doing a heart surgery and then come back to the lung surgery again, right? At that point in time, we take what is called as audio-video consents. So we call the family to a room, there is a camera, we record the consent, so the doctor can basically do the surgery. In that case, how do we handle consents?
No, so two things there. One is, I just told at the beginning, let's not sort of confuse something which is related to medical, the realm of medical
regulatory
laws,
consent.
Regulatory and the data law. Now coming to the data law, you would have seen Munna bhai, koi mar raha hoga to form bharna zaruri hai kya? Answer is no.
Okay.
There's medical emergency is a exception under the law which is stated. Okay. So therefore, we don't have a problem there per se. Now, if you are taking consent, this law again is not very prescriptive, in this sense. You can decide which ground of processing you want to opt for.
Okay.
It is up to you. If you want to state that consent is my ground for processing, then you follow all the consent related aspect. If you want to say no, medical emergency is my ground of processing, then you go down that route.
So just a follow-up question on the medical emergency part. So like GDPR has given that as one of the legitimate interest options, so we can still use that and the legitimate use condition?
So there is a similar leeway also here.
Okay.
Medical emergency is a
that helps.
Without calling it legitimate
Use.
and the consent which you were saying was more in terms of what happens to the patient. It's more like a contract type of environment. It's not much on the data, personal data regime, I feel. No one probably would go and consent that because you would process and not process my personal data, the patient died.
But also to safeguard from a medico-legal...
Yeah, absolutely. So that's what I'm saying. The medico-legal, let's slice and dice a little bit, okay? Medico-legal, if there's a requirement, please go ahead and do it. And check what is written there. If that is ticking the box, no problem at all. Data handling. This data law is giving you that leeway,
And,
that it's another of those legitimate...
That's clear. So the other one is about deletion. Somebody spoke about, okay, I want my data to be, now I'm withdrawing my consent, I have to delete the data. But obviously in many sectors, not only medical, but in medical, obviously we have to retain the data for 10 years or so to meet
That's also
regulatory
clearly
obligations.
exempted, no problem. If there is a
And-
law which is talking about it, no problem.
Yeah,
So when the deletion request comes to you, you can simply state that under this law, we are mandated to hold it for 10 years,
and
cannot be
we
deleted.
can probably say we will not process further by locking the record or something like that.
Those things, yes.
Yes.
In fact, in today's law, also Section 72A of the Information Technology Act, if you see, it's talking about if you have procured personal information pursuant to a contract, then you cannot disclose it, against the will of the person and against the consent. But it starts with subject to any other law for the time being enforced. So there's a very famous termination of medical pregnancy act, which is in conflict basically, which says that you have to store it for X period. And this lady said, no, I want to get it deleted. So that law prevailed over this generally.
Yeah, that's a thought process that we have just wanted to validate it. Thank you so much.
Sorry, unfortunately, we don't have time for any more questions, but feel free to take these questions offline. Our speakers will be here, I'm assuming, for a little more time. Thank you so much to all the panelists for a wonderful discussion.